Good morning or good afternoon to you. Welcome to today's Venable Nonprofit Organizations Group monthly webinar titled 2025 Year in Review for Federal Government Grants. I'm George Constantine. I co-chair the nonprofit organizations practice here at Venable along with Janice Ryan. And I'm happy to introduce today's program and let you know we're very lucky to have two of our country's foremost legal experts on federal grant compliance matters with us today. And they're going to offer some perspective on what has to be among the most consequential 12 months ever in this area when it comes to developments and changes and very significant changes over the last 12 months for sure. So Diz and Scott are going to give a review of the last year, but also give a bit of a perspective on trends and what may be continuing on and what may be changing into 2026. Before I introduce today's speakers, I'll just make a quick plug for February's webinar. It's going to focus on nonprofit election law issues. Given that 2026 is an election year, we want to make sure that we focus on this topic early on in the year and make sure that those who are interested have that chance to learn from our speakers and adapt and take the recommendations forward from there. So we're still finalizing a date, so keep an eye on your inbox. You'll get an invite for that program shortly, I'm certain. On to today's speakers. I'll start with Scott Sheffler. Scott is a partner in Venable's Government Contracts and Grants Group, and he focuses his practice on federal grant compliance, government procurement law, and internal investigations. Scott previously served as an attorney within the U.S. Navy and Military Sealift Command before moving into private practice. Scott's a relatively new addition from another firm here at Venable, so we're really happy to have him join us. And our other presenter is Diz Locaria. Has been with the firm for more than 20 years. I'm thinking close to 25, Diz, but I won't guarantee that. I think you're probably a little short of that. Diz has become a leading voice on all matters related to federal grants, particularly for our nonprofit organization clients. Many of you, I'm sure, recognize Diz and have had interactions with him, particularly over this past year. So we're happy to have both Diz and Scott on today's presentation. With that, I'll stop talking, turn it over to Diz to get started. Thanks.
Thanks, George. Appreciate it. And fortunately, I am a couple years shy of 25, but the gray hair probably doesn't show that too well. Here's our bios for everybody. And real quick, just given that some of the items we'll be discussing today, we want to make sure that folks understand that the views that we present today are not necessarily attributed to Venable, but are those of Scott and I. We've got a relatively packed agenda in this hour, so I'm going to jump right into it. But as George mentioned, we're going to talk about kind of a lot of things that happened in 2025, which was fairly unprecedented. So we'll talk about some of those important cases and principles and the trends deriving from those. We'll talk about DEI in the context of the federally funded programs. We're going to give an update on indirect cost rate cases. We'll talk about one of the more notable executive orders as it relates to grant recipients, 14332. With respect to questions, we're happy to take those along the way. Because we have a pretty packed agenda, we may not veer too far off course with questions, but we'll try to get to as many as we can as we go. There is a Q&A function, so please feel free to type and enter your questions in there, and we'll monitor that as we go to answer questions. But without further ado, let me turn it over to my partner Scott to kick us off on some of these recent cases in 2025.
Wonderful. Thank you, Diz, and to our nonprofit group, thanks for having us. To everyone who's joined, good morning and good afternoon, depending on where you are. So as everyone has already said, and I will echo yet one more time, it has been an incredibly impactful year, both in terms of executive action, somewhat actually in terms of, even though it's inaction until recently in Congress, and then a lot of action in the courts. And so while there are hundreds of cases involving actions on federal grants out in the world presently that are in different degrees, that are at different degrees of reaching, sort of working their way towards finality, there have been a number of cases that have been particularly important in terms of sort of setting out what grantees can expect in terms of their rights moving forward, and in terms of how they'll interact with the federal government moving forward. And so there's four that we wanted to highlight as we look back at 2025. We have sort of a summary here in this table. I'm going to talk mostly on the webinar from this table, but we will be sending out the slides after. And everything that I'm saying, we have in follow-on slides as backup slides. So you've got that as a useful guide to take home with you after the webinar. One of the most significant issues in 2025 made its way up to the Supreme Court. And in fact, one other comment on this. I would say that the level of judicial action that we have in the context of administrative law impacting federal funding, especially federal grants, but also federal contracts, is akin to the level of action that we last saw roughly 100 years ago with New Deal litigation. So it really is a significant time, both 25 and what we can expect in 26, in terms of setting out not just congressional authority, but presently, especially executive authority. So first case I want to talk about is this National Institutes of Health v. APFA case. This is the second case, actually, that made its way to the Supreme Court on this particular topic. And as many of you are aware, huge numbers of federal awards were terminated throughout the course of 2025, generally on the basis that those awards, in the view of the new administration, didn't effectuate the current administration's policy priorities. And many grantees, many trade associations representing universities, sued to try to enjoin those grant terminations, stop those grant terminations by court order. Most of those plaintiffs went to district court, where they'd be able to take advantage of arguments under the Administrative Procedure Act, and where they'd be able to take advantage of, at least at the time, what they perceived would be the power of those district courts to issue injunctions, a form of equitable relief, to actually order the agency to reinstate the grants. The administration argued and has argued repeatedly that, in fact, those grant termination cases didn't belong in the district courts, but rather, since they were fundamentally, in the administration's view, disputes over contract rights, they could only be brought in the Court of Federal Claims. One of the reasons likely that the administration made this argument is that if it can route these cases to the Court of Federal Claims, these termination cases, the plaintiff's sole remedy, or virtually their sole remedy, would be monetary damages somewhere down the line, and not the injunctive relief of reinstating the grants. And so it's very, if successful, right, this would be a very impactful change. That question of what court do grant termination disputes belong in went up to the Supreme Court twice. The second of those cases is this National Institutes of Health v. APFA case. And the Supreme Court was divided 4-4 on whether these NIH grant terminations belonged in district court under the APA, in part because they were based on background policy changes, or whether they belonged in the Court of Federal Claims because, according to the administration, fundamentally, these were terminations of the grant agreements as a result of those background policy changes. Well, the court was split 4-4. That meant that one justice, in this particular case, Justice Amy Coney Barrett, with a concurring decision, set for now, at least preliminarily, the law of the land on this issue. And what she held was that, to the extent that the plaintiffs were challenging the background policies, that was proper in district court, but to the extent that they were challenging the result of the termination of the grant agreements, those belonged in the Court of Federal Claims. And as a result, those terminations, there had been a stay in the district court of those terminations. And as a result, the Supreme Court stayed the stay, and those terminations continued to be in effect. So where we sit as we enter 2026 is that if the challenge that you have as a grantee, if the dispute you have with the federal government is over background policy, background regulations, chances are you can stay in district court or go to district court. We'll see that when we talk about indirect rates shortly. But if what you have is fundamentally a dispute arising from the agreement about the termination of the agreement, chances are you'll have a very difficult time finding any sort of relief in district court. You'll be routed to the Court of Federal Claims. And what we can expect in 2026 because of this decision is litigation in C.F.R, Court of Federal Claims, over what the proper amount of damages is in a grant termination case. So a lot more to follow on this. This is a fundamental change in the grant system. C.F.R, by the way, is probably a better place to be if you're fighting over money, like a disallowance. but in a termination case, it's tough to be there. So that's our first big trend-setting case. The second is this Radio Free Europe versus the State Department versus Kerry Lake case. This case is important. This was actually a less reported upon case than many of the other cases we saw in 25. But in my view, it's one of the most important because RFE won, and the reason RFE won their case is really important. So the background on this particular case is that Radio Free Europe was pending an award from the federal government. The award that was pending was their annual award to run their Radio Free Europe operations as a not-for-profit organization. But in their case, there was an actual statute that says this award shall be made annually to Radio Free Europe. And the administration was simply refusing to make the award for presumably policy reasons. So when Radio Free Europe went to district court and made the argument that the award had to be made, two things happened. First, the district court said, well, this doesn't belong in the Court of Federal Claims because there is no contract yet. This is a question over whether the agency internally will engage in the act of carrying out its statutory responsibility of making the award. So jurisdictionally, we're in the right place in district court. And then secondarily, because there is a statute that specifically says the award has to be made to Radio Free Europe, for the agency to fail to make that award would be arbitrary, capricious, and contrary to law under the Administrative Procedure Act. So the big takeaway out of this case, and this is one that I've discussed with a number of clients, is that if you can be named in the statute, right, if Congress directs an award to you as an organization, you'll be in a much stronger position in the event that there's some delay in the award being made or in the event that your award is terminated. And presently, as we get to the end of this presentation, we'll talk about some disagreements that we're starting to see between Congress and the executive, but being written into the statute can be helpful. Now, not everybody is Radio Free Europe, but there still are, we just saw with the recent appropriations, many opportunities to be written into, less directly, to be written into appropriation statutes through earmarks, what more commonly we describe as congressionally directed spending or community funding. So earmark opportunities are something to look at increasingly in a time of funding uncertainty. So that's Radio Free Europe. This third case, President and Fellows of Harvard, is significant in two respects. One, it was just noteworthy in the sense that the dispute between the administration and Harvard University has been widely reported upon. The administration attempted to terminate hundreds of millions of dollars in grants to Harvard University, and the stated basis for the termination was that Harvard was insufficiently protecting some of its students from discrimination on campus. In particular, in the public reporting, the allegations related to failure to adequately protect Jewish students during times of protest, etc. So this case, Harvard challenged the grant terminations in district court. And based on my discussion of the APFA case above, you're probably thinking, oh, well, can they challenge this in district court? Or were they in the wrong place, right? Did they get routed to the Court of Federal Claims? This case was important because there were two bases that Harvard raised that enabled them to stay in district court. So the first was they argued that the termination of their grants were a form of retaliation in violation of their First Amendment rights, and successfully convinced the district courts, now on appeal in the First Circuit, that because it was a First Amendment case, it belonged in district court. And secondarily, they successfully argued that because the federal government, in this case, I think the lead agency was HHS, but I don't recall specifically, failed to follow procedural requirements for enforcing Title VI obligations that are established by regulation. For that reason as well, the case, because it was an argument, it was a dispute over following the agency's regulations, in particular Title VI regulations, it also belonged in district court. So they were successful in staying in district court based on those arguments. And most importantly, in successfully making those jurisdictional arguments, and then also successfully arguing the merits to prevail at the district court level, they obtained the relief of having the grants reinstated. And that was that's sort of an important extension of the jurisdictional issue in the sense that it's not just a question of getting declaratory relief in district court, having the district court say legally they're right, but for a contract action, they still have to go to COFC as a secondary action. The district court reinstated the grants. And so that remedy was important. This case is one to watch. It will probably go to the Supreme Court. It's going to answer a lot of our jurisdictional questions in the wake of the NIH case. And then the last case I want to mention is this Trump v. Casa case. So this is actually not a grants case, but it has been hugely impactful in the context of grant terminations and other disputes between various aggrieved entities and the federal government in this year of change. And in this case, the big issue in this case was the question of whether if one or two or three plaintiffs go into district court and successfully argue their case and succeed in obtaining a preliminary injunction or a permanent injunction against some new regulation, some new agency policy, etc., can that injunction bind the agency that they're in the dispute with vis-a-vis the whole rest of the world? It's called a nationwide or a universal injunction. And the question of district court authority to issue these nationwide or universal injunctions went to the Supreme Court, again, not in the context of grants, but nonetheless, it's the Supreme Court. And the Supreme Court held that no, in fact, it's highly questionable that district courts would have the inherent authority to issue universal injunctions. That means the practical result of this case is that as plaintiffs are going into court to challenge grant terminations, going into court to challenge new agency policies like indirect cost rate caps, they can, generally speaking, even if they succeed on the jurisdictional issues, stay in district court, get the injunction, generally speaking, that injunction will only impact the plaintiffs in the case and those that the plaintiffs directly represent. So one of the practical results of this has been, there's sort of two key takeaways on this. One of the practical results has been, and something to keep in mind as we move into 2026, being a member of a trade association can be really, really, really helpful because those trade associations are going to court. And if they're successful, by virtue of the fact that they represent their members, usually you, if you are a member, will get the benefit of whatever that decision is, whatever that court order is. Secondarily, this case left open a question as to whether, if under the Administrative Procedure Act, new federal policy or regulation was voided through the district court remedy of vacatur, whether that would still be nationwide in effect. Presumably it would. And in cases since this Trump v. Casa case, we have seen that that is in fact the case. So under the APA, if you're successful in vacating an agency policy, even though you're the only plaintiff, if it's vacated for everyone, or at least that seems to be the outcome, and that's likely what we'll see more of in 2026. So Diz, now you will see as I turn back over to Diz, we'll scroll through a number of slides. Those are backup slides on everything that I discussed, and you'll have those as takeaways when we send out the slide deck later this week or early next.
Thanks, Scott. One thing I'll note on the NIH case is you may hear a phrase regarding what's called Tucker Act jurisdiction or the Tucker Act. And the Tucker Act is the statute that confers jurisdiction for these contract terminations to the Court of Federal Claims. So just if you hear that phrase, the Tucker Act is preventing us from being in district court, that's exactly the issue under the NIH case. And the Casa case, I'm going to be talking about the impact of that in my slides. So as Scott mentioned, we have backup slides for each of these cases here that you can peruse when we distribute those. So with that, I'm going to move over to our second topic, which is DEI in the context of the federally funded programs. So real quick to set this up, and most of you are probably familiar, so I'll go through this quickly. But there were a number of executive orders, two of which were issued on January 20 of last year, and then one that was issued exactly a year ago today on January 21 of last year. The first one is this one, ending radical and wasteful government DEI programs and preferencing. Essentially, this EO said that the federal government will not spend funds on government activities that prioritize or preference a protected class. So that led to a whole slew of grant and contract terminations relating to internal things that the government might have been doing that it viewed as violating these principles of DEI. The next one was issued also on January 20, and this one focused on what we call gender ideology, and it's defending women from gender ideology extremism and restoring biological truth. Essentially, this EO says that we recognize that there are two genders, and those genders are assigned at birth, and nothing else can be inconsistent with that. And so that mandated a lot of action internally within the government as it relates to gender issues. Um, Various government forms, those types of things were all modified to go back to two genders, and those genders are that which was assigned to you at birth. Um, and, programs that the government funded, both focused on its internal practices, but certain external things were also defunded and terminated as a result of this executive order. And then the third executive order, and probably the most impactful for this community, was the one that was issued on January 21, which is ending illegal discrimination and restoring merit-based opportunity. And this one essentially said, look, if we, the federal government, are going to fund you, you are not going to promote or advocate for DEI activities because we believe that violates the federal anti-discrimination laws. Importantly, what this EO also said is that we are going to require that grant agreements and contract agreements include a certification that says that compliance with this executive order is material. What that means is that if you sign a certification or provide a certification of the materiality of the federal anti-discrimination laws, that gives the government a very clear line to assert what's called False Claims Act remedies. The False Claims Act is a statute that is used extensively in the government contracting and grant community for noncompliance. And it needs to be material noncompliance pursuant to Supreme Court law. And so what this would demonstrate is that they would create materiality with this certification, and you could be subject to False Claims Act liability, which is a civil statute, not a criminal statute, but it does provide 3 times the damage of whatever that harm was. Now, there's a lot to be debated about what the harm might be about advocating or pushing a DEI, what is viewed as non-compliant DEI practices. What's the harm of that? That has yet to be quantified because we are waiting for our first False Claims Act case in this space to come, but it is, all indications are that will be forthcoming at some point, probably this year. But how that harm is going to be calculated will be something that is up for debate. But it is notable that there are False Claims Act cases where if harm is difficult to determine and it impacts the integrity of a program or the integrity of an agreement or contract, the government has taken the position that the entire value is the harm, and therefore it could be 3 times that. So that does create a very strong stick to force compliance. And because of that, we saw a significant shift in the community as they viewed and handled DEI activities. And we'll talk about some of that when I get into the cases. Some initial takeaways, grants were being reviewed on whether they were equity related, equity being a kind of a proxy for DEI. We saw a lot of grants being terminated or no longer, the funding was no longer picked up, even though it may have been something year over year. We're left, though, with a lot of questions still. What DEI initiatives are problematic? We got some varying guidance from agencies on recognizing Black History Month, for example. So you can recognize Black History Month, but can you promote it? Those are kind of lines and areas that remain today very gray. What constitutes promoting DEI or gender ideology? And then what is a violation of the civil rights laws? That is also remains to be kind of ferreted out here. These are the civil rights laws at issue here. And these laws, as you'll see, 1964, 1964, 1972, and then the most recent one, these laws have not changed. And they were today, on January 21, 2026, these laws are exactly the same. These laws have not changed. What has changed, however, is the intended interpretation by the administration and the Department of Justice, largely based upon the Students for Fair Admissions case that was issued by the Supreme Court a couple years ago, which provided, again, dealt with Harvard and dealt with Harvard admissions and the prioritization of protected classes. That case ruled against Harvard's practices. It was in the higher ed context, but it's very clear that this administration is going to look to apply that more broadly to employment practices, to program practices, and the like. And so that is kind of what we were reeling and dealing with early last year. Then last summer, the Department of Justice came out with a memo. We did have some agency guidance. OPM provided some guidance. Department of Education provided some guidance. We'll talk about that in a moment. But the most notable guidance was issued by the Department of Justice at the end of July of 2025. And it really started to clarify and provide examples of what was allowable and what was unallowable under the interpretation of the department and that executive order. And essentially, it said that, preferential treatment based upon protected class, race, gender was unlawful. And so it cited things like race-based scholarships or programs, preferential hiring or promotion practices that look to balance or create preferences for underrepresented classes. Those were prohibited. And then even access to facilities or resources based on race or ethnicity would be examples of something. Importantly, the memo also said, look, it's one thing to say specifically that you're promoting a certain race or gender, but we're also going to be looking for proxies. And those proxies we view as unlawful in the same regard. So things like cultural competence requirements or geographic or institutional targeting. For example, if certain areas or certain institutions cater to a certain group of people, that could be viewed as unlawful. Things even as kind of vague as narratives in college applications or scholarship applications where you've been asked to describe how you've overcome obstacles. That could create advantages to certain protected classes and was viewed also as potentially unlawful. So those proxies have kind of spread how far and wide this interpretation is intended to go by the Department of Justice. They also talked about the segregation of the workforce and segregatory activities based upon race. But then when it got into gender, it was a little bit different because the administration has a different view on gender. And it's kind of the converse. In other words, whereas the segregation on race is certainly unlawful, the segregation of gender, they wanted to make clear, was lawful. And in fact, required in certain instances as it relates to restrooms and probably the bigger topic that is actually was before the Supreme Court just a couple days ago, dealing with athletics and women or men participating in athletics under a gender that's different than their birth gender. So things like race-based training sessions would be viewed as problematic. And then segregation in facilities or resources would also be viewed as problematic. One of the areas that folks talked about extensively is things like affiliation or employee resource groups, where you have, underserved communities might have certain groups to support their efforts. Those could be viewed as segregatory within the workplace and create either a segregatory workplace or even a hostile work environment. And here's another example, but I do want to move through the slides here with a little bit of speed. So as it related to the unlawful use of protected characteristics, DOJ's memo went on and then talked about other things like diverse slates would even be something that's unlawful, or sex-based selection of contracts or race-based selection of contracts. All of those types of things would be viewed as unlawful because it would be based on a protected characteristic. And then things like training programs were either going to be viewed as segregatory or creating that hostile work environment because it may impact or exclude or feel like individuals are penalized based upon their protected characteristics. For example, things like unbiased trainings and those types of things were called out in the memo as being potentially unlawful. So that obviously had significant reverberations through the industry and caused, a number of folks to react and modify their practices based on that. So what are you supposed to do and how do you modify, right? Well, they do provide at the end of the memo what they view as encouraging certain activities, which is inclusive access, right? Not limiting access to anything based upon a protected characteristic or a proxy, right? It should be focused on skills and qualifications. It should not be demographic driven or any data driven policies there. And it should be based upon documented, legitimate rationales. Proxies are an issue. Going to eliminate diversity quotas and avoid exclusionary training programs. So those are all things that were specifically called out, which obviously had a significant impact on how folks had maybe been handling their workforce or their programmatic activities previously. Okay, so moving on from that memo, we're going to talk about, I'm going to touch on DBE regs real quick, and Scott, happy to have you jump in if you like. And then I want to talk about a few of the DEI cases and how those are evolving as we go. But as you can imagine, as we're talking about DEI, the federal government itself has a number of DEI programs. And one might argue that is this calling into question the legitimacy of those programs? Yes, the answer is yes, right? There's 8A programs, there's women-owned programs. The Department of Transportation has disadvantaged business enterprise programs where the DOT and the state agencies certify DBEs and MBEs for priority in Department of Transportation funding. Well, this obviously has created, some upheaval there. And in October, the DOT modified and amended its regulations to remove these programs altogether. Many states have similar programs, and so those are all going to be issues that we're going to see at the forefront of this coming year and how state issues, state programs now will commingle with Department of Transportation in this context and the federal government at large in other contexts. Scott?
No, thank you, Diz. The only thing I would add on this is that what we've seen in 25 is that the sort of key element that's being, I'll say, removed from these programs, both by courts and now by the current administration, is elements of the programs where there's a presumption of disadvantage based on gender or being a member of a particular ethnic group. Those presumptions are, by and large, now in one way or another, either enjoined by courts or removed by the executive. That was the sort of the driving thrust behind these changes to the Department of Transportation DBE program regs. The second piece, sort of the flip side of that's important as we get into 26, because a lot of grantees bring this question up, is 200.321. If you're thinking 2 C.F.R. 200.321, your obligation as a grantee to encourage participation by small businesses, minority businesses, women-owned businesses, etc. There's nothing about that language that thus far is problematic, because if you go, and I encourage you to go take a look at the specific language of the regs, all of the language of those regulations, and similarly for example, for the good faith efforts regulations for the EPA, is focused on increasing the potential for participation, generally through race neutral or sex neutral means, without having quotas, mandates, etc. The grantees that are experiencing challenges in this area are not grantees that simply are complying with federal regs. It's the grantees where the federal regs don't specifically say have a quota, but maybe they have state contracts that say, look, you have to meet minimum standards. And those grantees are now concerned, well, is that going to create problems for me from a false claims standpoint on my federal awards? So that'll continue to evolve in 26. I said
Thanks,
more
Scott.
than I intended, as I appreciate it.
No, no, that's fine. And it gave me a chance to look over a couple questions I'm going to try to answer quickly as we move on. One question was, um, would uh, is it likely that scholarships for historically black colleges, even though race is not a criteria, be prohibited? I think there's some real risk there, right? Because the Department of Justice memo talked about institutions, right? So HBCUs, largely their their student body is largely African American, and so I think that there is scholarships and things that are specifically directed towards those universities that could be an issue. Obviously, we have to see how all this plays out. There hasn't been any actual litigation in that, or any guidance or any rulemaking. So we'd have to see how it plays out. But I do think that there are significant risks when you look at institutional allocation or geographic allocation. The other question in this kind of related is my mentioning of cultural competence and whether that would include non-English languages in order to work with immigrant populations. There, I think you actually have, I wouldn't call that cultural competence. I would call that a skill, right? Being bilingual and the job requires you to speak with people that don't speak English. I think that's an actual a skill, an attribute that is objective and demonstrable that you would avoid, um, you know, liability there. You would have a very strong argument, I would think, if that were the case in that situation. Okay, let me jump into. I'm going to talk briefly just about a few cases here, and then move on to the next topic because we just have a lot to cover. This first case, the National Association of Diversity Officers versus Trump. So this case was the first DEI case filed. And this was filed here in the District Court of Maryland. And actually, a preliminary injunction was granted by the district court. It found that there were, that the executive order was vague, it likely infringed on First Amendment rights, and had a lot of issues with that. Unfortunately, that case, or however you want to couch it, that case was then appealed by the administration to the Fourth Circuit. And the Fourth Circuit actually said, look, this is just an executive order. This hasn't been implemented with a rulemaking or anything else. This is just a aspirational goal of the administration. It's premature to decide this right now. We need to see implementation. Now, I think practically speaking, one might argue that things had been implemented. I don't think that was pled maybe perfectly at the early stages because the administration, even to this day, there isn't a formal rulemaking on these DEI executive orders. We're still waiting for a FAR clause or a term in the uniform guidance that says what this certification actually means or what this certification actually will be. So the administration is actually implementing through the bully pulpit, sort of, and also through agency guidance. So the Fourth Circuit said, look, we're going to they went ahead and stayed the injunction on that basis. And the case is now, so that injunction's not in place. The case is still being heard by the Fourth Circuit. They had oral arguments in September, and we're waiting on a ruling there. Importantly, though, this case actually preceded the CASA case that Scott talked about injunctions. And this had initially imposed a nationwide injunction, but that injunction was stayed. And then other cases on other issues like CASA came forward and set ground rules for district courts and their injunctions. And that takes me kind of to the next case, which is an example of where we're at with this DEI. So a lot of the district courts, and in this case, the Court of Northern Virginia, or Northern District of Illinois, also implemented a preliminary injunction. And a lot of the district courts have had a problem with this executive order because it leaves a lot to be desired. What does it mean to promote and advocate for DEI? How is this, constitutional against the First Amendment, against vagueness? And so a lot of the district courts have had problems with this. But as Scott mentioned in that CASA case, the nationwide preliminary injunction power of the district courts the Supreme Court said, you guys need to reel it in. You need to have a really strong basis if it's going to be a nationwide. Otherwise, your remedy needs to be to the plaintiffs. And so this case, hearing it out, many of the same arguments that were in the case in Maryland, but this district court issued a nationwide injunction, but only against the Department of Labor in its implementation of the DEI executive order. So you have an injunction against just the DOL. Now that was appealed by the administration up to the Seventh Circuit. And so that has been argued, and we're still waiting to see what the Seventh Circuit decides. But that injunction remains in place, but again, only against the Department of Labor. So we're starting to see that there's a patchwork of injunctions against DEI. Another one that I want to highlight, Northern District of California, not surprising, they granted a preliminary injunction, but this was against AmeriCorps and how AmeriCorps attempted to implement the DEI EOs. Again, they found issues with vagueness, First Amendment, all the sorts of issues that we've been seeing. So the preliminary injunction was entered, but only as applied to AmeriCorps' efforts. The government initially appealed that case, and then they withdrew their appeal in September. And so the district court case for a permanent injunction remains ongoing at the district court level, and we'll hopefully see a decision on that very soon. Then there's this National Education Association versus Department of Ed. I mentioned that agencies had done their own implementation up to that DOJ memo. Department of Ed is really well known for issuing what we call a Dear Colleague letter. This Dear Colleague letter set out that institutes of higher education, i.e. universities, would lose certain funding if they violated the tenets of the DEI EO. The National Education Association filed a lawsuit. The district court in New Hampshire granted a preliminary injunction covering the plaintiff nonprofits. So to Scott's point about association coverage, but again, that only enjoined the enforcement of the Department of Ed's Dear Colleague letter, right? So it is again another patchwork. So we have DOL, we have AmeriCorps, and here we have Department of Ed's Dear Colleague letter. So again, since we don't have a nationwide injunction, we have a patchwork, and many agencies are not subject to these injunctions. Both sides have since filed motions for summary judgment, and we're waiting for a final decision in that district court case. Now, the last case I just want to talk about briefly here is a little different in that it is the state of Tennessee actually challenging a federal program that challenged the Hispanic Serving Institutions program, which is a federally funded program. And it's alleging that the federal government is violating the law based upon this program aimed at Hispanic students. Not surprising, I guess, the Department of Education, the Department of Justice have announced that they don't intend to defend the case, leaving it open to who is going to defend this program. Well, that's where the Hispanic Associations of Colleges and Universities stepped in to defend the program. Now, that case is still in the pleading stages, but it's important in that even federally funded programs might face scrutiny by states or other organizations that bring suit. And this administration may not look to defend those programs. And so other organizations may have to step in, as is the case here. So with that, we've only got 15 minutes to go. So I'm going to turn it back to Scott to talk about indirect cost rate caps.
No, and I think we're good on timing. The themes out of indirect cost rates that are really the key takeaways are the canary in the coal mine themes for sort of what we'll see in 26. I do want to say we need to give the CLE code. It is Government Grants 2026. Government Grants 2026. We'll announce that. We'll announce one more code as we proceed through our next 15 minutes. So and one other very quickly before we get to the rate cap issues, there was a question on indirect. Well, we've got a number of questions. What we'll do is we'll answer those to the extent we can at the end. But for the 690 question, the Form 690 question, the indirect rate question, and the question on state and federal tension, if you don't get an answer in this session, feel free to email Diz and I, and we'll make time to answer it. So in terms of the rate cap, so what we saw in 25 was a series of efforts by policy changes to cap the indirect rates, the indirect rate levels that could be set or could be recovered on awards, federal awards, primarily for institutions of higher education, but also extending in some cases to other grantee types. This started with a broad rate cap policy change issued by NIH that was looked at largely as an institution of higher ed rate cap actually in the early months because it was asserted by NIH as immediately applicable to all from that day forward. It's actually, I think, 2 days later forward for all IHEs. But the way the rate cap was worded is it would apply to all grantees also with new awards moving forward. National Science Foundation. So all of these rate caps were enjoined by courts. I'll get to that in a moment. So none of them, if you're thinking, oh my goodness, I didn't know about this rate cap, don't worry, none of these are currently applicable. But NSF followed suit. They issued a rate cap of 15% over modified total direct costs. This was for all institutions of higher education. Department of Defense followed suit also and issued a rate cap of 15%. They didn't specify a base, but it was implied that it would be modified total direct costs. If we keep going, there's the Department of the Department of Energy also issued a rate cap of 15% for institutions of higher education. And then the Department of Energy did the most interesting thing of all the agencies, and they actually also, for state and local governments and for nonprofits other than institutions of higher education, they issued a policy indicating that indirect rates and fringes would be capped at either 15% or, if you were a governmental entity, 10% of total award amount. So instead of capping your indirect rate, they took the approach of saying, we're going to cap line items in your budget, which arguably is a stronger approach by the government. All 5 of these were challenged in federal court. 4 of them were challenged in the District for Massachusetts. And the state and local, I guess I should say that the nonprofits other than institutions of higher education rate cap that was imposed by the Department of Energy was never challenged in court. The state and local version of that cap was challenged in the District of Oregon, and it was enjoined there. There were basically 2 arguments that were made in federal court with great success. For NIH, so one of those arguments was relevant only to NIH, and that argument was there's an appropriations rider, so language in the appropriations statute, the HHS appropriation every single year that specifically states that NIH can't cap rates. Apparently, this was an outgrowth of an attempt under, and I don't actually recall this happening, but under the first Trump administration in 2017 to cap rates. So in the 2018 HHS appropriation and every iteration of their appropriation statute moving forward, we saw language that prohibited NIH from adjusting the way that they would calculate indirect rates. So in the NIH case, that statutory language operated to provide a win to the plaintiffs. The district court said that, in fact, the attempt to cap the NIH rate was unlawful. And then this was appealed to the First Circuit, and they agreed with the District of Massachusetts. In that process, they also said, by the way, this is a policy issue, so this belongs in district court. There were arguments made by the government to move it over to COF-C as a contractual issue, and those arguments up through the First Circuit have failed. The second reason that the court in the NIH case said that the rate caps were unlawful was simply based on the structure and language of the uniform guidance itself, which provides a very detailed mechanism, very detailed process for negotiating rates, whether they're provisional rates, predetermined rates, final rates, etc. That same argument, the second argument, is actually particularly important because that was also the argument that prevails with the NSF rate and the DoD rate, and even the rate that ostensibly capped budget line items for state and local governments that was imposed or attempted to be imposed by the Department of Energy. So if we keep going through the rate cap slides. So where we are as we sit right here today is that none of the attempts at rate caps have been successful. And as an outgrowth of this litigation, those who were affected apparently have been successful on Capitol Hill. What we have seen is a number of successful legislative initiatives to impose barriers by statute upon agency flexibility, so limits on agency flexibility in potentially capping rates moving forward. One of the limits that has now been enacted into laws with respect to DoD. So in the 2026 National Defense Authorization Act, Congress told the executive, and in particular DoD, that it would be unlawful or imposed a legal restriction on DoD that they could not cap indirect rates until they had certified to both the House Armed Services Committee and the Senate Armed Services Committee that they had gone through a process working with affected parties, primarily institutions of higher education, and establishing some alternative methodology that would control costs but would still provide for reasonable cost recovery for those institutions. So if you're an IHE, what you should hear in this and what you should read when you read the certification language is Congress has essentially endorsed, well, most likely is essentially endorsing the C.F.R model that's been circulating throughout the last year. If you're an IHE, you know what that is. And if you're not, don't worry about it. In addition to the NDAA language, the appropriation statutes that we now see trickling out at the end of January 2026 also have riders that are not identical to the NIH rider, but impacting a number of agencies. So we have, it's not signed into law yet, but it has passed both the House and the Senate. The Commerce, Justice, Science, Energy and Water Development and Interior and Environment Appropriations bill should soon be the Appropriations Act, so it'll soon be law, and it imposes barriers, at least for this year, on the Department of Commerce, Department of Justice, NSF, and through a separate section, which you'll see on the slides. In fact, if we go to the next slide, Department of Energy on imposing rate caps. We expect to see something similar for NIH. Just yesterday, reported by the appropriations committees for the House and the Senate. We're now seeing text on a compromise bill for the HHS ed and labor appropriation. And that text, which hasn't passed either body yet, does include language that will prevent rate caps in NIH. We did see in an early version of a House appropriations statute for HHS education, labor and related agencies, that there was a notion of possibly actually by statute capping rates for about 40 institutions with the highest endowments. That language, by my read, fell out of the text that's the compromise bill that we're looking at that came out yesterday. So good news that went away. Big picture takeaways on indirect rates. So we have an effort to cap cost recovery by policy. We have both based on the language of the uniform guidance and statutory language that's now becoming more prevalent with the new appropriations statutes, courts stepping in to stop the administration from arbitrarily capping those indirect rates. And we have now differences of view by Congress and the administration on how grant programs should be treated. So all of this tells us a little bit more about what we can expect to see in 2026. On the flip side, as Diz is about to talk about, we also see the executive reacting by changing the uniform guidance. So go ahead, Diz.
Thanks, Scott. Yeah, so the last section we'll talk about here, and I think we'll have a couple minutes for questions. I know we have a lot of questions, but I won't take the remainder of the time on this section, is to talk about what I'll say is one of the more recent, albeit it's about 6 months old, executive orders impacting grant recipients. And this is 14332, which is directly focused on the oversight of federal grant making. So this came out in August and created a lot of hullabaloo as well in the grant community because, first of all, it directed that agency heads direct a senior official to be directly involved in the review and decision for funding opportunities and to ensure that those are consistent with agency priorities. Now, the reason that is significant is you're talking about high-level political appointees deciding all grant-making decisions to make sure that they fit within the administration's priorities and their national interest. That is unprecedented. I mean, as some of you may know, I mean, there's many grants that are very, very small, thousands of dollars. And this is saying essentially that a political person needs to be deciding all of those grant funding arrangements. This could bring things to a screeching halt. It could, we'll have to see how this kind of plays out in practice. But what it does do is it puts a target on these political appointees that if they award something that the administration then finds objectionable, that person may not be long for their job. So it does put a lot of accountability on these agency heads to act in a politically motivated way, which may not align with merit-based opportunity executive order, but it is what it is. So that could be extremely impactful. And it also talks about, that discretionary awards need to advance the president's priorities, right? So you have some awards that are directed by statute, but here where we're talking about discretionary funding, agencies are going to lose a lot of that kind of flexibility and discretion they had because now political appointees that are going to be directly accountable to the president are going to have to direct those funds. So I think all of this probably, is going to be something we'll have to see how it plays out. I'm sure that there'll be some differences among politicals across the agencies, but certainly something to keep in mind. It also talks about updating and amending the uniform guidance, which is what Scott was just referencing. So one of the key things that happened during last year was the termination of these grants. Now, some of you are probably aware, maybe most of you are aware, many of those grants were terminated under a concept or a perspective of what's called termination for convenience, meaning the government doesn't have to have a reason or a cause to terminate. It's terminating because it doesn't believe this is advancing what it espouses to be the goals of that agency. And so a termination for convenience simply means that the government as a sovereign doesn't want to spend money on that any longer. That generally that concept is in every government contract, and it's actually in there even if it isn't specifically in the contract, it's read into the contract under certain case law. But those are government contracts. In grants, that concept, until the transition from Trump to Biden and back to Trump, didn't really exist in the grant community. But there has been this battle from Trump to Biden to Trump about the ability of the administration to terminate agreements. And when it went from Trump to Biden the first time, the Trump administration had revised the rules to provide for termination with considering the effectuation of agency priorities. Biden changed the rules to say, yes, that can be done only if that term is specifically incorporated into the terms of the grant. That obviously wasn't done with a number of grants. But when the Trump administration took office this last go around, they went ahead and terminated anyhow based upon effectuating agency priorities. A lot of lawsuits ensued, Tucker Act arguments, and that is still kind of playing out. But what the Trump administration has said under this executive order is we want the uniform guidance to be amended to clearly articulate that grant awards can be terminated without cause when it no longer effectuates agency priorities. That will give the administration a much stronger argument legally to terminate these agreements without issue. So that is going to be forthcoming in the revisions that we anticipate to the uniform guidance. We also anticipate revisions that will limit the use of discretionary grant funds on certain indirect costs like facilities and administration. Scott talked about a lot of things being done at the legislative to try to preserve some of this, but at the regulatory level in the uniform guidance, the administration is likely to limit and limit some of these cost-related issues as it relates to indirects. We also expect articulation of this agency head review to go in there, and then also requiring, more affirmative authorization by agencies when it comes to drawing down funds and requiring grantees to provide certain written explanations for support for those drawdowns, tightening the controls around the drawdown of funds. All of that is notable, and we also would anticipate changes with DEI and that DEI certification making its way into the update on the uniform guidance. So a lot to be expected in 2026. We've talked about a lot of the cases, but also, we're waiting for this uniform guidance update, which we anticipate any day now. And we will certainly be keeping you guys apprised of that. I do want to note that we have a listserv for our client alerts there at the bottom, so please feel free to sign up so you get the latest on any grant related developments. And I apologize because I thought I would go faster, but I didn't. And so we're actually a little over time. Scott, any parting thoughts?
Well, I want to say government grants 2026 is the CLE code again. The government grants 2026 is also the second CLE code. And then no parting thoughts. Now I know we didn't get to questions. Our emails are here. Please feel free to reach out. A lot of the questions are very good questions. Some of them have very sort of short answers. So feel free to reconnect with Diz and I.
Thank you, everybody. Really appreciate your time.